with a motion to suppress as well. Could you have that filed? Could you have that filed by December 16?
Yes, Your Honor.
All right, now I have defendants. A defendant's motion for discovery relating to a breach of the defendant's telephone security and recording relating to attorney-client communications. I think I have two separate motions in this regard. One related to a Rule 14 request for the DAs, both here and in Bristol County, and the sheriffs of Suffolk and Bristol counties. Then I have a second motion under Rule 17 for the third-party records of Securus Technologies. I take it both sets of motions are relating to the same conduct. That is, a claim that recorded phone calls that may have included attorney-client phone calls were improperly accessed or hacked into.
Correct, Your Honor, and just to make sure that Your Honor has the same documents that we're referring to the same documents. You should have two sets of documents that bear essentially the same name. The most recent set filed yesterday are intended to essentially replace the ones filed November 21st. We've learned a great deal and essentially expanded the motions. So I'm not sure whether Your Honor has had an opportunity to review the December 6th.
No, I had reviewed the earlier ones. I didn't see that these were supplemented.
We thought it easier to just submit two new motions.
Well, let's deal with what was filed yesterday
Very well.
as the operative motions. One entitled Defendant's Motion for Discovery Related to Breach of Defendant's Telephone Security and Recording Attorney-Client Privilege Communications. And that is the one that focuses on discovery from the DAs and the sheriffs of Suffolk and Bristol County.
Correct.
Correct? The second motion that was filed yesterday is a motion under Rule 17 for an order compelling Securus to provide information.
Correct.
All right. Now, let's deal with the motion focused on the DAs and sheriffs first.
Very well. If it pleases the court, I'm going to ask Mr. Leontire to address this in substance.
That's fine. But before we do, let's find out if this is a live issue in this case. Mr. Leontire, are you aware of any actual recorded communications between your client and any attorney that were in fact recorded and preserved?
I am not aware, Your Honor, of actual conversations between my client and his attorneys. We are aware that conversations, and we don't know, and I'll explain why, whether attorney-client calls were involved, that there was a specific breach of Mr. Hernandez's phone calls in 2013, if I strike that 14, while he was a detainee in both Bristol and Suffolk. We believe it occurred in Suffolk. That breach has been apparently acknowledged by the sheriff.
All right, now hold on one sec, just so I understand what is claimed here. Is it a breach separate and apart from the hacking into the Securus Technologies system? Or is it part and parcel of that?
Okay, there are a number of, it's separate, but let me explain how separate.
Okay.
There are a number of hackings into the Securus system. There are many, as a matter of fact. The specific hack with respect to Mr. Hernandez's phone calls, at least from the information publicly known from the sheriff, was directed at him alone, at his calls alone. There are other breaches, and frankly, we haven't gone through them. There were 70 million phone calls that were breached, of which, by some estimates, over 14,000 calls were attorney-client privileged calls. The issue with respect to whether it's live regarding attorney-client privileged communications is as follows. There appears to be a pattern and a problem with the Securus system. And we have examined other cases, and there's a case in federal court in Kansas where there are affidavits filed, and the master report by the court just was filed yesterday. We provided a copy to the court and the prosecution. What has happened is, the way the system is supposed to work is that an attorney records their number with the sheriff's office, and they are supposed to be, through some electronic means, through Securus, put in a do not record program. The fact is that program has failed, and that in one of the most recent ones, which was the filing yesterday by the master in federal court in Kansas, he notes that over 200 and some odd attorney-client privileged communications were in fact turned over to the U.S. attorney through the correctional facility, and no one was aware of this until what happened was the defense began to notice when they started to get discovery that there were calls made to them that were in the discovery information. Now, this has happened not only in Kansas, it's happened in California. We've supplied the court with a copy of a complaint, and I know a complaint is an evidence, but in the complaint they articulate all the attorney privileged communications and the process that they have discovered so far that was supposed to not be recorded by these local correctional facilities. So we are not convinced, and I will not represent to the court because I don't know at this point, we are not convinced that any representation by anyone at this point that attorney-client communications were not recorded and somehow accessed, and I'll get to the access issue in a moment, and that's why we're seeking this discovery. We know there was a breach of telephone calls. We don't know what was recorded. We know that attorneys' calls are in fact being recorded by Securus. We know that they're being recorded by Securus whether or not people have filed their do not record. And finally, there's this issue, and we've asked for the information. We've provided you with a communication from Washington State between the Director, Investigative Services for Juvenile and Adult Corrections. And he asked them in an email which was produced pursuant to a Freedom of Information request, who has access to the Securus system. 82 detectives have access to the Securus system in that jurisdiction, as well as numerous other
Yeah, I saw that. Access how?
They can go online, put in a code, and they can listen to any communication they wish.
And who grants them access? Securus or the local institution?
Well, that's a good question, because theoretically the local institution. But the local institution was asking Securus who had access, because they were not maintaining their records properly. People were leaving, they still had access. So all that we're really seeking here, Judge, is to find out the calls, the process, what calls were recorded. We can tell that very easily by matching it up to the attorney's calls.
Okay, hold on for a moment. Let me see if Mr. Hagan can give me some information on this. Mr. Hagan, first, are you aware of any investigation that the District Attorney's Office or any other law enforcement agency has underway relating to a breach of the Suffolk County Sheriff's system?
I am not aware of any such investigation.
And are you familiar with the system utilized by Suffolk County and other correctional facilities in Massachusetts to record prisoner or pretrial detainee phone calls?
Generally, yes.
Do you know if Massachusetts uses Securus as its vendor?
I do know the Massachusetts Department of Corrections does. I do know the Suffolk County House of Corrections does. I don't know about other correctional facilities.
And the focus here, I think, is on Suffolk County and on Bristol County. Do I take it that Mr. Hernandez was housed in Bristol County before the trial down there?
He was, Your Honor, and during the trial, he was transferred to Suffolk.
Let me see you folks up here at sidebar for one moment.
That is correct.
From where?
From the Suffolk County House of Corrections, from the Bristol County House of Corrections, and from the Massachusetts Department of Corrections.
And in terms of accessing them, just out of curiosity, how were they accessed?
They were accessed through subpoena process to the facilities. The facilities provided the Commonwealth with a CD from which on a computer with a certain codec that has to be installed on the computer, the calls, and they're all non-attorney calls, and those are excluded based upon the phone numbers. The phone calls can be accessed via the computer. All such CDs the Commonwealth obtained in the course of the investigation have been turned over to the defense.
When you say you obtained them by subpoena, what form of subpoena?
It depends on which calls. The calls that were obtained during the course of the grand jury investigations, those were obtained by grand jury subpoena. Subsequent to that, the Department of Corrections changed their rules and regulations to allow the disclosure and dissemination of recorded calls of an inmate upon a prosecutor's written request for such. So the latter calls since the date of that policy change have been obtained without subpoena but through request of the Commonwealth.
With regard to the requests you made or with regard to what was provided, did it include a call log?
Correct, yes it did.
Relating solely to Mr. Hernandez as opposed to other inmates or
That is correct, solely
detainees?
Mr. Hernandez.
Was it represented to be a complete log of all telephone calls?
It was represented to be a complete log of all non-attorney telephone calls. I should clarify one point that Ms. Anderson raised. There was provided as Mr. Hernandez's calls pursuant to his PIN number. It's not out of the realm of possibility that people can use each other's PIN numbers, but I have no evidence of that in this particular case.
And with regard to the call logs that you received, that was from all three institutions?
Correct.
Were they provided in discovery?
Yes.
Counsel, have you seen those call logs?
Excuse me, Your Honor, I have not. I know I have not seen them, but I will, if I could, respond briefly, Judge.
Well, just
Okay.
to follow
No,
up
I
on
haven't
this,
seen it, Judge.
stay put, I'll hear you in a sec. Just with regard to that, call logs typically, if I'm correct, are created by an inmate PIN number, a pretrial detainee PIN number, and then indicate the number called
Right.
as being one of the approved or authorized phone numbers. The question then is whether any of those telephone numbers are known to be numbers of counsel. It's a way of saying that I think you may be able to tell, based on the discovery you've already received, whether in fact there were any attorney-client communications that were recorded, at least according to what's been provided.
Judge, I understand that, and I agree with what the statement so far is.
Yeah.
Went. However, the question of attorney-client privileged communications is not just what is turned over to the district attorney, but what is accessed by anyone involved in this investigation. And without the information from Securus to tell us so that we can, number one, evaluate the calls, and number two, determine who accessed these calls. We already know it was breached.
Okay, we'll get to that in 1 second.
Okay.
The breach that you're aware of, I saw in the pleadings a reference to Suffolk County Sheriff becoming aware of a breach as the result of some investigative audit of some sort or investigative review. It wasn't clear to me what that review, what triggered that review. Was it a routine review, or was it the result of some inquiry as to Mr. Hernandez particularly, or did it flow from a data breach at Securus? Do you know at all?
I do not.
Okay. Do you know, Mr. Hagan?
I do not.
All right. No one's inquired of the Sheriff's Department in that regard, is that right?
I have not.
And with regard to Securus having 70 million telephone calls, I'm a little curious as to how that happens and whether or not Securus becomes the archive for all institutions, whether they are the storage unit for all calls.
They are, Your Honor. I can tell you that.
They are.
They are. The local district attorney, strike that, the local sheriff's office has the terminal. I do not know to what extent the terminal maintains records, but I do know that the system is designed for all the records to be maintained at Securus. I can also tell you that...
But it seems to me that the local institutions also have the capability to reproduce calls. They can burn a disk quickly with regard to an inmate PIN number,
I don't know...
produce all those calls and turn them over. Isn't that what you ended up with, Mr. Hagan?
Exactly right.
I'm trying to determine whether Securus would have anything more, anything greater than would the local sheriff, or is the local sheriff the first avenue of storage?
Judge, I don't believe the local sheriff maintains any storage of phone calls from my understanding of the Securus system. It is my understanding when a request or a subpoena is made that that information is provided by Securus to the sheriff and that it is then produced at the local terminal. That is my understanding. I could be wrong, but I have had, we have another matter with Securus pending and outside of the criminal arena. And in my discussions with Securus to date, that is my understanding.
All right.
I would also like to just inform the court, pursuant to this motion,
Yep.
we've attached, in the civil matter, we received a preliminary injunction by Judge Stern with respect to the preservation of all the material that Securus has. Subsequent to that, after an emergency motion was denied to revoke that, we came to an agreed-to stipulated motion with Securus, which Judge Stern approved, and I provided the court as an exhibit number 7, to to the Securus request, discovery request, a copy of that stipulated to PI, preliminary injunction. I will say that the preliminary injunction is in order to preserve at this stage, not to produce, but that information matrix was worked up between Securus and myself as to the nature, how their system works with respect to information and retention, and what they had agreed to preserve in that context.
Exhibit 8, you have 7. When you reference Exhibit 7,
Yes, sir.
is that Exhibit 7 to the motion filed yesterday?
Yes, sir.
Okay, I do have that. So you have an agreement to preserve
I do, Your Honor.
all the categories of information you are seeking by way of this motion?
We have a court order,
Okay.
preliminary injunction, stipulated order, yes.
Very good. Here's what I think is appropriate. We can take this up on December 20 as the third motion to be dealt with on that date. Part of what you're asking for are records or information from the Suffolk County Sheriff, as well the Bristol County Sheriff, and that most properly should be a Rule 17 request. I'm going to treat the motion that you filed as a Rule 17 motion relating to the Suffolk County Sheriff and Department of Corrections and Bristol County Sheriff. And I will order that they produce any and all records of recorded calls or calls made on Mr. Hernandez's PIN number, including any calls to counsel or to a number identified as counsel, together with any information as it relates to any recording, inadvertent or otherwise, of attorney-client communications. I think you're entitled to know that, although if I understand it, Mr. Hagan, the Commonwealth, at least as far as you know, has not accessed, has not listened to, and would not intend to present any attorney-client communicated phone calls.
I think that's accurate, Your Honor. I think we haven't had access to any calls from Mr. Hernandez to his attorneys, to the direct line attorneys. We obviously don't have anything that we intend to introduce.
All right.
Your Honor, may I ask one further question?
What would be helpful on December 20 is to have someone here from the Sheriff's Department or Department of Corrections or Bristol County that are familiar with their particular systems, who could explain. We all know how these calls are made, how they are recorded. For the most part, I think most of the institutions are fairly similar in the way in which they track calls and by automation record the date, time, number called, and so forth. What we don't know, I think, is how that is stored, who actually stores it, and how it is retrieved. That is, whether you go through the vendor being Securus, or whether the institution has the capability to produce that on their own. I must tell you that in past cases, institutional authorities have testified that they do all of that. And that they don't have to go through a third-party vendor, but maybe it's different now.
Your Honor, if I ask two things. In your order to the sheriffs, we would like to know who has access to their recording system.
I suspect the best way to find that out is to have a witness here.
Okay. And one other question. Would it be possible if Your Honor is not inclined to order any information from Securus at this point, would it be possible to request that a representative Securus be here as well for the 20th? I think they'd be amenable to that based on my discussions.
Well, then you can call them and bring them here. But I don't see the need at this stage to bring in Securus unless we find that Securus has something that the local authorities do not have, or has some capability that the local authorities do not have. I'm not convinced at this stage that they do. And where you're not alleging any particular harm as it relates to Securus, other than generalized hacking of everyone's calls, I don't see the need right now to bring them in.
Okay, what about the report that has allegedly been produced and investigation that was done by Securus and the sheriff regarding the alleged hacking, not the alleged hacking, the hacking of the phone calls that we know took place in 2014. Allegedly, these entities have, the sheriffs and Securus, have a report with respect to that hacking.
Okay. Is that a report you've obtained, Mr. Hagan?
No, I have not.
When I mean you, I mean the whole prosecution team. You don't know anything about that or have any report on that?
I do not have a report.
Okay. I think it'd be helpful that we have that report, so likely I'll include that within the order.
Thank you, Your Honor.
All right. What else, folks?
The Commonwealth did file a motion for reciprocal discovery.
Yeah, you filed that today?
Yes, Your Honor, we filed it today because we also filed the certificate of discovery compliance of all known mandatory Rule 14 discovery, at which time, as the court's aware, is the appropriate time for the Commonwealth to then file the motion for reciprocal discovery pursuant to Rule 14A1B.
Mr. Sullivan, did you just receive that today?
I did. I have.
I'll give you until December 20 to address that. Don't feel the need to file a written response. I'll be happy to hear you an argument on December 20, as to your obligation to produce reciprocal discovery under the rules.
Very well.
Okay. What else?
Your Honor, there are two other motions. One, I think that we're going to be able to work out with the prosecution, which is our simple motion for Corey. Is that correct, Mr. Hagan? I think we're...
Yes, I believe the Corey motion there's agreement on that.
Well, that's great. Where is it?
I believe that was filed and certain aspects were sealed relative to personal information of the witnesses.
Is that filed today, counsel?
No, Your Honor. November 21st. And can we get a date, Your Honor, when we receive that? Normally it's produced right after indictment, but...
All right, Commonwealth, what do you say to that?
Your Honor, it's my understanding that the motion was directed to the court and then the probation department would run the records. That being said, if it will expedite matters, the Commonwealth will certainly run the records of witnesses and provide copies to counsel.
If you're willing to do that, that would make it a whole lot easier. Is that satisfactory to you?
Yes, Your Honor.
All right. Then the Commonwealth, thank you for that, Mr. Hagan. That will make it easier. Can you do that within 10 days?
Certainly.
Is that agreeable?
That's agreeable.
Very good. All right, and you said one further motion?
Yes, Your Honor.
Yep.
Your Honor, filed on November 21st was another motion. It's called Defendant's Motion to Order the Commonwealth to submit an identity history summary check with the FBI for certain civilian witnesses. Let me make sure Your Honor has a copy.
I do have a copy.
Okay. As you know, Your Honor, we will receive the Corey records. As Your Honor also knows, this case involves witnesses from several jurisdictions. It involves an action in Florida that involves witnesses in Florida. Under both Massachusetts law and constitutional Sixth Amendment rights, in Massachusetts we're entitled to question witnesses depending on the nature of the offense and the court's relevancy, review of the criminal history of the witnesses.
You're entitled to what?
To impeach.
Yes, you can impeach witnesses.
Thank you. So the problem we have is we have a lot of out-of-state witnesses here. Now, there is a process called III, which
Is that what you're asking for here?
No.
Okay.
And the reason I'm not, I mean, I'd want III anyways, but the reason I'm not, we're going beyond III is as follows. III is a system with known serious defects, and those defects are as follows. The last study by the Justice Department indicated that hits between fingerprints versus III is that III misses 11.7% of the criminal activity, criminal records of people who just apply under III. The reason for that is that III uses names, and lots of times names get entered into the system wrong, birth dates they get entered into the system wrong, and the only reliable way, especially in a multi-jurisdictional case with multi-jurisdictional witnesses, is through the fingerprint FBI records. And it's a process, it's a very well-known, articulated process. Virtually every government agency with respect to law enforcement has access to it and uses it. And we're not asking for all witnesses. It may be, I think the number is probably around 10 witnesses that we'd like to make sure that we have their full criminal history given their out-of-state activities, out-of-state residences. And if the court would allow us to do this, I think we could work with the prosecution to find a way in the probation department to do this easily.
Okay. I'm not sure what it is. I've never heard of an identity history summary check. But I take it is something, it's a database other than III.
Well, it's the same database, but there are two ways to access it by the FBI. One is through name.
You wanted access through fingerprint?
Yes, sir.
Mr. Hagan, is that something you're familiar with?
I've never in my 2+ decades as a prosecutor heard of this process. I did advise counsel of that, so I am not aware of this ever being done before. The problem the Commonwealth has among many is the aspect where it appears fingerprints would have to be taken of witnesses and ultimately submitted to this database, which again, I don't think is the authority for it. The showing us has certainly been made to require witnesses to submit their fingerprints and require another agency, a government agency, the Federal Bureau of Investigation, to run this identification check. I think it's unprecedented, Your Honor.
Okay.
Your Honor?
Yep.
I know people have practiced law for a long time. I've been practicing 35 years. But you just go on the internet and put in the FBI records requests, and this is a very well-known process. As I suggest, every law enforcement agency that submits fingerprints goes through the system. And it's available to employers. It's available to all types of individuals. And the only thing that's required here is that it be on government-approved stationery. And I've listed for you in the motion the specific criteria that has to be included with the issue. I think that any of the agencies, detective agencies or police departments or probation probably has the ability to do this. And again, I'm not looking for everyone. We're just looking for a small number of people.
All right. And do we know who that small number of people are? Are they listed in the motion?
I don't have the names listed, but I can provide them to Mr. Hagan immediately. Well, within the day or so.
All right. I'm going to table this until December 20 to give the Commonwealth some time to see if they're familiar with the system, either the DA's office or the police. I must say I'm not familiar with it, but I see that you have attached a 1999 report of the National Task Force, and I will take a look at that.
That's just some selected readings, Your Honor. If you'd like to see the whole report, we've given you the site.
No, the less the better. Okay, that will be on for December 20, but I've allowed the motion for quarry records within Massachusetts, and that will be provided within 10 days, correct?
Correct, Your Honor.
Okay. Anything further, counsel?
Not on behalf of Mr. Hernandez, Your Honor.
All right. Let me see you folks up here for one last time.